This is Stephen Carmona, a man facing a felony for repeatedly violating a court order meant to protect his ex-wife. He's about to stand before a judge who is known for her zero-tolerance policy on disrespect. In a series of intense hearings, we'll see him receive one of the most brutally clear warnings a judge can give, promising up to 10 years in prison for any misstep. But the warnings don't stick. He'll be back in the same courtroom for the same case, facing a motion to revoke his freedom entirely. The final showdown will hinge on one simple question: did he follow the judge's direct order? His answer will trigger a dramatic real-time confrontation, pitting his word against the sworn testimony of his own probation officer. Is he a man trapped by circumstance or a manipulator who has finally run out of chances?
Court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense.
Johnny Cisneros for Mr. Carmona.
Are you Mr. Carmona?
I am, Your Honor.
Did you understand by information you're being charged with repeated violation of a court order or bond condition family violence? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your
Did
Honor.
you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
I do, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Court
Your
will
Honor.
find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
I do, Your Honor.
According to the plea, there's a $0 fine. State recommends deferred adjudication. They're taking in consideration CM 112993, and there's to be GPS tracking only. Did you understand that to be the plea?
I don't believe the GPS. I thought we talked about not having.
That's it.
No, but you had said no, so I said no.
Okay. We can remove the tracking.
All right, so there's no GPS tracking.
No,
Yes.
GPS. That's right.
All right, did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your supervision be for a term of 6 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Linda, Lynda, Stephanie Cortinas Hernandez. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Sure.
Then to the offenses charged by information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer States Exhibit 1 and its attachments.
No objections, Your Honor.
And state, have you spoken to the complainant?
Yes, Your Honor. The state has spoken with the complainant and let her know that this is how we will proceed with the case.
All right. You may be excused to continue to confer. We'll find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits,
The defense attorney paints a picture of a fine young man caught in a volatile situation. This is standard procedure. Humanize the defendant for the court. But Judge Boyd isn't here for the pleasantries. She's read the police reports, and she's about to cut directly to the core of the issue. Notice how she completely bypasses the lawyer's softball pitch and prepares to confront Mr. Carmona directly. She's going to ask him a simple question: why does he keep showing up where he's not wanted? His answer will be his first major test with this judge, and it's a test he's about to fail spectacularly. The judge is already signaling that she sees this not as a misunderstanding about child arrangements, but as a deliberate pattern of behavior that needs to be stopped dead in its tracks.
1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
All right, anything you wish to say on behalf of your client?
Your Honor, I just got to meet him a little while ago, and he seems like a fine young man. His parents are here. He's been brought up right. He's had a couple of issues before, nothing serious, but I think this is a good deal for him. It's a volatile situation that we have in front of us with his wife. And when we finish this, I'm going to call his divorce attorney and let the divorce attorney know what's going on and how they need to proceed to protect him on my end.
All right, Mr. Carmona, are you employed?
I am, Mr. Honor.
What do you do?
I'm a call center manager.
What does that mean? For which company?
So I work for Go Health What we
Okay.
do is Medicare licensed agencies to enroll 65 and older.
All right, why do you keep showing up at Ms. Hernandez's place? She doesn't want you anymore.
A lot of things were just to assist with the children.
She doesn't want you anymore. Do you understand what protective orders mean?
Yes, ma'am.
That means that you can't have any contact. That means that when I read in the police report that you're at the apartment, she's not there, which means if she's not there, that means that there are no children there. How old are the children?
He's 4 years old.
He's 4. So when you went to her apartment and she wasn't there, there was no 4-year-old there. So don't come before me telling me that you're doing this because there are a lot of child things going along. You still want her. She doesn't want you. She doesn't want to be bothered by you. The only time you can see her is when.
This is a masterclass in judicial warnings. Judge Boyd isn't just giving legal instructions, she's spelling out the reality of a no-contact order in brutally clear, everyday terms. Seeing her in the grocery store, you leave. Walking down the same street, you leave. She's demolishing any potential gray area he might try to exploit later. She's speaking to him not just as a defendant, but as a 42-year-old man who needs to understand that the relationship is over. The charge is for repeated violation of court orders, which means this isn't his first warning. The court is drawing an uncrossable line in the sand, and the message is simple: accept it and move on, or your next stop is a prison cell. This is his final explicit chance to absorb that message.
You all are in civil court with the divorce. Do you understand?
I do. Yes, ma'am.
How old are you?
42.
You're 42 years old. How long were you married?
Almost 7 years.
7 years?
So,
So that means that you've been alive on the planet longer than you've been married to her. Let it go. You're not a teenager. She doesn't want you. If you violate the conditions that I'm going to give you, what's going to end up happening is you're potentially going to prison for 10 years. Do you understand?
yes, ma'am.
Is there anything that you do not understand that I'm saying to you?
Oh, ma'am.
If you are at the HEB and you see her at the HEB on aisle 2 or whatever, you need to leave that HEB. If you see her walking down the street and you're walking on that same street, doesn't matter if you got there first, you need to leave that street. Do you understand?
Yes, ma'am.
She does not want to be in a relationship with you. If you all are working out arrangements through your divorce where there's child arrangements, that needs to be done through a third party. Do you understand?
Yes, ma'am.
And if she gets involved in another relationship with somebody else, not your business. Do you understand? Well, you say yes, but you're here for repeated violation of bond conditions and protective orders. She doesn't want you. You got to accept it and move it on. You understand?
Yes,
And
ma'am.
if on the inside you are breaking down and your heart is broken and you think it's broken in a million pieces and it will never recover, pretend like your heart is not broken and keep moving. You understand?
And there's the reversal. Just minutes ago, the plea agreement explicitly said no GPS tracking. The defense even clarified it with the judge. But after listening to Carmona's excuses and acknowledging his history, the judge has changed her mind on the spot. This is a perfect example of a judge exercising their discretion. She heard his rationalizations, weighed them against the charge of repeated violations, and decided he can't be trusted on his word alone. She's now ordering GPS tracking as an insurance policy. This isn't just a condition, it's a direct message. She's telling him, I don't believe you will stay away on your own, so I'm going to make sure you have no choice. This is a significant blow to the defendant who thought he had just dodged that particular bullet.
Yes, ma'am.
All right, this is what the court is going to do. There's a $0 fine, 6 years deferred adjudication, take in consideration CM 112993. There's to be no contact with Linda, Stephanie, Martinez Hernandez. And when I say you have contact during court hearings, that's through your attorneys. So there's no out in the hallway, hey, let's be nice to each other, let's work. No, you're not to have any conversation.
With the terms of his 6-year deferred adjudication set, including the last-minute addition of GPS tracking, Stephen Carmona leaves the courtroom. But this story is far from over. We now jump forward in time. Carmona is back in the same courtroom, in front of the same judge, but for a new issue related to a different allegation. The court is about to add yet another layer of conditions to his already strict probation. Pay close attention to the new order the judge is about to give him. It seems like a simple instruction, but his failure to follow it will become the entire focus of his next and most perilous court appearance. The seeds of his next downfall are about to be planted right now.
Conversations with her, you understand?
Yes, ma'am.
Unless it's court ordered. So there's to be no contact with Linda Stephanie Cortines Hernandez without a court order. Proof of employment within 30 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation with him and to follow TAP recommendations. 100 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are complete, the 100 hours community service restitution will be deemed satisfied.
Thank you.
All right. And Mr. Carmona, because of your history with this violation of protective order, I am going to give you GPS. I'll do tracking only. I'll waive the fees. Counsel, once he shows that he's able to obey court orders, come back in about 4 months. We'll see how he's doing. So GPS tracking, waive or defer fee.
Daily sober meetings. Not weekly, not 3 times a week, daily, 7 days a week. The judge is responding to a new issue, likely related to alcohol, that's come up since his last appearance. This is an incredibly demanding condition. She is making it crystal clear he has until his next court date on August 26 to attend meetings every single day and bring her proof. There is no ambiguity here. For a man who already has a demanding job and family responsibilities, this is a heavy burden. But for the court, it's a non-negotiable term of his continued freedom. The judge's tone is firm. This isn't a suggestion, it's a direct order, and it's about to become the central point of failure in this entire saga.
Fees. Are you going to be living with your parents? Where are you going to be staying?
My house.
You have your own place?
I have my own house.
All right, I'm going to want field visits 1 time per month until further notice. Probation, is there anything else he needs? Is there anything else you need from the court?
No, ma'am.
All right, we can go off the record from here on out. Everything that you do, you need to ask yourself 2 questions. One is, what I'm doing, could it potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand? And I am serious about you not having any contact with her. I don't know. This is the last time I'm going to say it. She doesn't want you. She doesn't want to be in a relationship. She doesn't want a Valentine's Day card from you. She does not want a Happy Mother's Day card from you. Do not send that. And if you do any of those things, if you email her, if you text her, if you send a card, if you send flowers just because, if you send something saying, I apologize for the way I behaved and this divorce is my fault, that will be a violation. Do you understand?
I do know.
And do not have third parties contacting her unless it's your parents or somebody approved by probation to make arrangements for child visitation. Do you?
And here we go again. We jump forward once more to the most critical hearing yet. This isn't just a check-in. It's a formal motion to revoke his community supervision. The state is officially trying to take away his probation and potentially send him to prison for up to 10 years. The reason? A violation for drinking alcohol, which he is about to admit. But the real drama isn't about what he did, it's about what he didn't do. Remember that order for daily sober meetings? The judge is about to ask him for the proof she demanded. His answer and the excuses that follow will lead to a stunning courtroom confrontation that pits his word directly against his own probation officer. This is the moment of truth.
Understand?
I didn't know.
All right, good luck to you.
Thanks.
Thank you.
And I was going to ask that, Judge. Thank you.
All right, the court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona. Can I have parties announced for the record for the state defense?
Johnny Cisneros for Mr. Carmona.
And are you Stephen Carmona?
Yes, ma'am, I am.
So now let's address the issue with blood draws or discovery.
Judge, this happened on May 26th, May 27th of 2024. Blood results are coming back. Usually minimum about 3 months.
Okay.
We're looking like it's been August. If we are pushed to contested, I mean, we probably could proceed on a different allegation that we could probably prove up by bringing the officer in. Other than that, Your Honor, my understanding is they may want to try to work out a deal on both.
By pleading true to the violation, Carmona admits he broke the rules of his probation. This is a huge strategic move. It avoids a lengthy hearing where the state would have to prove he drank alcohol, but it also puts him entirely at the mercy of the court. His fate is now completely in Judge Boyd's hands. His defense attorney immediately starts pleading for another chance, arguing that aside from this one mistake, he's been doing great. But Judge Boyd's focus is about to shift to something much more important to her: the daily sober meetings she ordered back in July. She remembers her order distinctly, and she's about to ask for the receipts. This is the question that will define the rest of the hearing.
Cases, so
Okay.
that's why we were looking to get it set off so that we could actually get the blood results back.
All right. So when are you all asking this to be set?
You know, it'd be probably late August, because that would make August 26th would make it 3 months.
Please.
All right. So we'll recall for August 26th.
No, Your Honor. That is the single most dangerous answer a defendant on probation can give to a judge's direct question about a court order. He immediately tries to launch into an explanation, but the damage is done. The judge ordered daily meetings, and he is admitting under oath that he did not do them. Now everything hinges on his reason. Was it a legitimate, unavoidable conflict that he properly reported to the court or his probation officer? Or was it a conscious decision to ignore a direct judicial command? The judge immediately stops him, makes him raise his right hand, and puts him formally under oath. She knows this is a critical moment, and she wants every word of his excuse on the permanent record.
And Mr. Carmona, as a condition of the bond that your counsel has made, you are going to do daily sober meetings until we come back on August 26th. Do you understand?
Yes, ma'am.
And your counsel be able to tell you where you can have those sober meetings.
When you say daily, 7 days a week,
Pardon?
you said daily?
7 days a
7
week.
days a week?
Yes, and those are NAAA meetings. All right.
I know where 12 is at.
All right, so we're going to recall the warrant. And we'll come back on August 26th, and you need to bring me proof that you've done those meetings. Do you understand?
Yes, ma'am.
All right, is there anything else?
Yes, Your Honor, and I heard what you explained in the case prior to us.
Mhm.
But I'm asking the court if we can put him on tracking on GPS. He's been on tracking on the MTR case since about October the 23rd, on partial, I'm sorry.
Mhm.
And we're asking that we be on.
This is the anatomy of an excuse. Carmona lays out a detailed narrative: his demanding director-level job, his 7 to 7 work hours, his 5-year-old son, his ex-wife's evening work schedule. He then claims that because of all this, he couldn't find a single virtual meeting that fit his life. He also adds a layer of technical blame, claiming the court system still showed an active warrant, which his probation officer allegedly told him was a reason not to report. He's painting a picture of a man trapped by circumstances, trying his best but thwarted by logistics and system errors. The question is, will the judge buy it? She's heard countless excuses before, and she's about to put his to the ultimate test.
Tracking only, so.
Well, if I may.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand, state your name for the record.
Stephen Carmona.
All right, what did you want to say?
Originally I was put on GPS for the offense for violating the no contact order.
Mhm.
And that was in the beginning of October, I believe it was 5th or 6th that I got put on GPS tracking only.
Mhm.
I have had no contact with the person since then, so now for 9 months. The issue that I'm having is that I have one in employment, my corporate career, that I gotta go, I'm on call, I'm a call center director. And I understand I've already submitted to my officer, my
All right, so
work
this is what I can
schedules.
tell you. If you want to be on tracking only, I will need the state to be able to contact the complainant to see if the complainant has any issues with that. And when I ask if the complainant has any issues with that, I just really want the complainant to be aware. Of course, I ultimately make the decision whether it's tracking or partial. So your counsel will need to confer with the state, and then you all can come back, and you can come back on any date for me to address that issue.
Okay, sounds good. Thank you, Your Honor.
All
Would
right,
he have to come back or just me?
he can appear by Zoom.
Okay, thank you, Your Honor.
All right, thank you.
Yes, ma'am.
That'll help with my 5-year-old.
This is a brilliant power move by the judge. She's not going to let this devolve into a he said, she said argument based on excuses. She is cutting through the noise and going straight to the source by ordering the probation officer, Norma Gara, to appear via Zoom. She is setting up a direct, real-time fact check. The defendant has built his entire defense on the claim that he communicated his problems to his probation officer. Now, that officer is about to testify under oath. The tension in the courtroom is palpable. Carmona and his lawyer know that his freedom now hinges entirely on what Officer Gara is about to say. The judge has escalated this from a simple review to a high-stakes credibility contest.
All right, the court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona. Could I have the parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
And Johnny Cisneros.
And are you Mr. Carmona?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
I did. Yes, ma'am.
Are you the same Stephen Carmona who was placed on deferred adjudication in 2023 CR 8639W for the offense of repeated violation court order bond condition on October 3rd, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 2 on or about.
That is the sound of the defendant's entire defense crumbling under oath. Probation officer Gara delivers a devastating 1-2 punch. First, she testifies that sober meetings were never discussed with him. Then, when the judge presses, asking if he ever told her he was unable to do the meetings, she replies, "Not that I can recall, Your Honor, no." She directly and unequivocally contradicts his entire story. He claimed he told her about his scheduling conflicts. She says it never happened. This is a catastrophic moment for the defense. The defendant hasn't just failed to follow a court order. He now appears to have lied about it to the judge's face just moments ago. He is in the worst possible position, caught disrespecting the court's authority, and then fabricating a story to cover it up.
On the 5th day of October 2023, Bear County, Texas, Stephen Carmona visited there concerning alcoholic beverages violation condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
And state with regards to the other violation?
Will be one allegation.
Any objection?
No objections, Your Honor.
Okay. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Do, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
No, there's not, Your Honor.
All right, state, what are you recommending? All right. And defense?
Judge, I'm recommending that you continue him on probation. He's been doing good. He's been on the GPS for 11 months approximately. And he hasn't had any violations. It's in the actual report that there's no violations. There haven't been any violations. And other than drinking alcohol that day, he's been doing wonderful.
This is pure desperation. The defendant is now arguing directly with the judge, trying to add new details to his story, claiming the conversation happened on the exit as he was leaving probation. Then, his lawyer seizes on the only sliver of hope he can find, the officer's phrase, "Not that I can recall." He argues this opened the door to the possibility the conversation did happen. This is a classic defense tactic, trying to turn a firm denial into a fuzzy memory. But it's a long shot. The officer was clear in her testimony. The lawyer's argument sounds less like a legal strategy and more like a last-ditch plea, hoping to create just enough reasonable doubt to save his client from the consequences of what appears to be a blatant lie to the court.
He's doing good. He's been following my advice. He's been following the court's advice or orders. And he's doing great, except for that one mistake, bad decision, not a mistake, bad decision. And I'd like for him to just continue him on probation and let's keep seeing how he continues. And if he continues to do well, then he'll be successful.
All right, so last time we were here in July, the warrant was recalled. And I asked that he complete daily sober meetings. Has that been done?
No, Your Honor. I recently have.
Let me have you raise your right hand for me.
Oh.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Stephen Carmona.
All right, so I ordered daily sober meetings. Why hasn't that been done?
I recently got an employment as a director of operations in a call center. Gives me 7 to 7 hours, Monday to Friday. I also have a 5-year-old that I share like joint custody with. So I have him anytime his mom is at work. She works in the evenings. So she goes in anytime between 7 p.m. and 9 p.m. So because of that, I couldn't find any virtual AA meeting. And the only ones that I could attend would start at 10 o'clock.
All right, so did you come into the court and tell me or tell your probation officer, hey, I know the judge ordered daily sober support meetings, but here's the issue I'm having?
I did tell my probation officer this past time that I saw Ms. Guerra, and she did tell me that I could go online for resources, and she provided me a link and information so I could go and start attending it. This was this past week.
All right, so I had ordered that since July 11th. Why are you only doing it this past week?
So initially, when I did talk to my probation officer, Ms. Guerra, she had told me not to report because of the fact that the systems were still showing an active warrant. So the last time I was in here, I was detained. I thought it was for failure to appear here, but it was, she told me that it was failure to report, which I wasn't aware of. And when she did call me and tell me, that's when I went and reported, and that's when I gave her all the information.
All right, any other questions?
Other question.
Ms. Abrams?
Yes, Judge.
So has he spoken to his probation officer about the sober support meetings?
Judge, I was just reviewing, the notes on the case.
Your Honor, if I may,
Yes.
I would like for you to continue him. And I will promise you, I will have a very stern conversation with him about following the court's orders. I know it's July and then August, so we're missing a few days here that he didn't do.
Just when it seems like Carmona's fate is sealed, the probation department throws him an unexpected lifeline. Another officer points out all the things he's done right. He completed his parenting classes, which gave him full credit for his community service. He's passed 3 drug tests. He's paying his fees. And most importantly, in nearly a year on GPS, he has not had a single violation for going near his ex-wife. This complicates everything for the judge. She's dealing with a defendant who is compliant in the most important ways, protecting the victim, but defiant and seemingly dishonest in others. This isn't a simple case of a bad probationer. It's a mixed bag, and the judge now has to weigh his dangerous disrespect for her authority against his tangible progress.
What he was ordered to do. But I will have a very stern conversation with him. I will tell him, as he already knows, the possible results of what can happen if he doesn't follow the court's orders. But I've gotten to know Mr. Carmona since he retained me. He is a fine young man. He has been doing well with the orders other than the alcohol consumption and this. So if I may get in a little bit of an extension for him so he can start doing what he needs to do. And then we're due back in January. So on the other case, and we can come on that day or we can come anytime in between there, Your Honor.
All right. Ms. Abrams?
Yes, Judge, I did review the notes that were in the system, and no notes indicate that conversation was had in regards to sober support.
All right. So let me ask you this. Is it possible to have his probation officer zoom in?
Judge, the probation officer listed is on modified duty. I can make sure, due to health reasons, I can
Okay.
make sure she's in the office and see if she can.
All right, then if she can't zoom in today, I can recall this. I've accepted his plea of true. And we can recall it for a date where she's able to zoom in.
It seems like 5 minutes, but
Sure. All right, if you all will step back.
Thank you, Your Honor.
You're welcome. All right, so we have Officer Norma Guerra here. Any objection to the officer appearing by Zoom, state?
No, no.
Defense?
No, ma'am.
Do you have any objections to her appearing by Zoom?
No, ma'am.
All right. Ms. Guerra, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Officer Norma Maya Guerra.
All right, any objections to the court just getting to the crux of the issue?
No, ma'am.
All right, so officer, the court ordered Mr. Carmona to do sober support meetings daily until, beginning July 11th until today. Mr. Carmona has testified that he spoke to you about his inability to do the meetings. Is that correct?
Sober meetings were never discussed with him.
We discussed it on the exit when I was leaving.
On the exit when you were leaving, I don't
Yes, ma'am.
recall talking about sober meetings, sir.
All right, so Officer Guerra, did you ever speak to him about sober support meetings?
No, ma'am.
Did he ever speak to you stating that he was unable to do his sober support meetings?
Not that I can recall, Your Honor, no.
All right, any questions?
Nothing from the state.
Any questions?
No questions, Your Honor. Just re-urge my argument.
All right, thank you so much, Officer Guerra.
You're welcome. Is that it, Your Honor?
Yes,
Okay.
thank you. All right, so the officer has testified that no one spoke to her about sober support meetings and the inability to do those.
We spoke, Your Honor. It was on the exit because I had told her that I was ordered to do 7 days daily, and she was surprised because I felt like it was a lot for me to do, given my situation, my income, everything that I have to pay for. She's the one that told me. I told her that I've researched 12 and 12. I need to be a member to do the virtual meeting at 7 o'clock in the morning. She also was the one that said, well, I've had another person that I've been working with, and I advised him to Google virtual alcohol meetings. It was on the exit as I was leaving probation. I wouldn't come up here and put myself at the mercy of the court trying to claim some ownership for what I've done. I understand that it's wrong, right? I do. I fully take responsibility for that. My thing is that, you know, like I was telling Mr. Cisneros, is on paper, it might look like I make money, but I got a mortgage, I got child support, I got utilities, I got other fees like GPS and probation and bondsmen. And so when it's all said and done with, I'm limited. You know, I got my 5-year-old that I take care of half the time, so his mom can go to work in the evenings. I mean, there's a lot of things that I'm doing, you know, and that's where I ask for you, please, to reinstate my probation. And, you know, it's one of those things where I've gone through a whole bunch of stuff. My divorce after 18 months was finalized in July. It's just a whole bunch of stuff that's been going on. And
All right, any questions, state? All right, so Ms. Abrams, in state, in the defense. So in this case, the person I have before me, this is his first motion to revoke, and it's for drinking alcohol, which he's not allowed to drink alcohol. I know I ordered sober support meetings, and that wasn't done. And I do know that I tell everybody, if there's an issue, you can come back to court and address it with me. And I guess when I order people to do things, they're like, you know what? Let me just come before the judge and say, I wasn't able to do it. Instead of coming in, nope, don't give me attitude. All right. Instead of coming in and saying, I have an issue with sober support meetings. This is what's going on in my life. Then that could have been something that perhaps we could have figured out. But when people are doing their own things and then come to me at the end of the day trying to figure something out, something should have been figured out in July.
I agree.
Your Honor,
I don't mean no disrespect at all, you know, and it was maybe something that I just didn't know. I mean, I have called up here to the courts and I talked to, you know,
I tell people to come in.
yeah.
Do I not tell people that they can come into court? Just one second, Ms. Abrams, there's something you wanted to say?
Oh, no, Judge.
Okay. All right, so
Judge,
then,
if I may say one more thing,
yes,
and excuse me for interrupting. The probation officer opened the door about there being a possibility that he did talk to her about it, because she said, not that I can recall. So I'm believing my client that he did talk to her about it. And of course, there's still the he said, she said situation, but she herself, and I'm gonna repeat myself, but she said that not that I can recall. So I think, again, if I may re-urge my request of the court to just give him another chance, I'll have a very strong and stern meeting with him and conversation, and tell him that it's, while we understand it's a zero tolerance policy now, I will make sure and reassure that he knows what zero policy means, and we can put him on or zero tolerance. So I'm asking for one more chance for him. I've gotten to know him, like I mentioned. He's a wonderful young man, just didn't follow the court's orders, and I don't think he understood the gravity of the situation. And we're just asking for a continuance, Your Honor.
anything else from the state?
No,
All right. Anything else from probation?
Judge, I would like to point out that, Mr. Carmona has completed his parenting classes, which gave him full credit for his community service hours. He has given 3 negative UAs. He is, paying toward his fees, being on GPS. He's not received any other violations.
Okay.
So just those points to give the court to consider.
So what he has done as a violation of his probation, he was placed on probation October 3rd, 2023. And this is his first violation, and it's drinking alcohol.
that's correct.
All right. You are not allowed to drink alcohol while you're on probation, period. Doesn't matter if you're in your house, doesn't matter that alcohol is legal. Those are the rules that the legislature set up. It is not my rule per se. It's the legislature's rule. You're not allowed to drink alcohol. Do you understand? All right. I'm going to continue him because this is his first motion to revoke, and it's for drinking alcohol. I'm not removing GPS. That's going to be a punishment.
Understood.
So he's going to have GPS for 60 more days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And I want those sober support meetings, and you're going to do sober support meetings 60 and 60 days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And for the last time, this is what I'm going to say. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can walk into this courtroom. Do you understand?
I do. Yes, ma'am.
All right, thank you.
Thank you.
Yes.
Yeah, I apologize. During his last TAP evaluation, it was, based on the information that was provided, substance abuse treatment was not recommended at that point.
Mhm.
I would like to see about getting another TAP recommendation completed based on the offense that was, the drinking alcohol, and then maybe a little bit of his previous, criminal history.
All right, so it's going to be deny the motion, alter the amend conditions to include a TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient, we'll start with outpatient treatment. There's going to be 60 sober meetings in 60 days and 60 days GPS.
Your Honor, would the court be open to an oral motion for the waiver of the fees of the GPS?
The only thing is I can ask that they be deferred and waived, but that's a third-party contract.
Okay. Thank you, Your Honor.
All right, is there anything else?
Not
In a stunning turn of events, Judge Boyd gives him one more chance. Despite being directly contradicted by his probation officer and admitting he ignored a court order, he avoids having his probation revoked. The judge continues his supervision, but makes it clear this is his last shot. As punishment, she denies any relief on his GPS tracking, ordering 60 more days, and then reorders him to complete 60 sober meetings in 60 days. She ends with a final piercing warning. If there is an issue, he is to walk directly into her courtroom and tell her himself no more excuses. This case is a powerful look at judicial discretion, where a defendant's compliance in one area earned him just enough grace to survive a catastrophic failure in another. What did you think of the judge's decision? Let us know in the comments below and subscribe for more courtroom breakdowns.